me is Bill Baldino from AIM, the Employer Resources Group. Laurie Burgoyne has actually joined us from Employer Resources Group today, and Terry Cook is calling in, but we're not 100% sure on technical issues, how she'll be able to call in and participate. So we're here to talk about two different issues. One of them is an update on employee handbooks and what's going on. The second has to do with some significant changes to the Workforce Training Fund program that Bill Baldino spent a number of years working on, helping some of you work through the grant program. With these new changes, we wanted to make sure Bill had an opportunity to come in and catch you up on what some of them were, and for you to have a chance to speak with him about them. In that vein, since I'm about to do the handbook presentation first, if any of you have specific questions you're already aware of on the Workforce Training Fund program, and you'd like to make sure that Bill touches on those topics, by all means, please send an email or a question rather in now, and we will make sure Bill's aware of that when the time starts for his part of the presentation. We want to make sure that we realize that every so often we talk about employee handbooks a great deal internally, the merits of them. I do a lot of handbook reviews. Terry speaks with a number of you about handbooks and handbook reviews. But we wanted to take a webinar to do a presentation to make sure all of you were sort of current with what some of the areas are, the trends are we're seeing, and as you decide how you're going to do a review of your handbook or when you're ready to do a review of your handbook, some of the things that we'll be talking about during that review process. Okay? And also the government agencies that are looking at your handbooks and what that may mean for you. It's stuck. Okay. So, quick review. What are handbooks for? Obviously, they're a bit of a sales document for you to make sure that your people understand the company. They're also a chance for you to convey what your policies, your practices are. What's your vacation, what's your attendance policy, what's your benefits, how do you handle employee classification, discipline, things like that. And trying to get basic questions answered. How are you going to respond to these particular situations? What do you expect of your employees? Obviously, those are good things. You have to communicate, put information there consistently, and it helps trying to reduce the risk of misunderstandings or lawsuits. However, as you'll see when we go through the next number of slides, there are a number of governmental agencies who take the view of it's sort of a snapshot right now, whereas you might think your handbook is a living document that will be able to be interpreted and implemented. A number of governmental agencies take a snapshot of it at that moment, and that often works to your detriment. So, at the get-go, and something we'll be talking about toward the end as well, is you try to figure out ways to reduce the risk of litigation. You want to make sure, and this comes up for me a great deal when I do handbook reviews with member companies, make sure that there's a policy and a practice, that they're consistent. So if your policy says the following standards about discipline, is that really how your supervisors, managers, whomever are doing that? That's crucial for you to know that and be clear on that. No problematic area to make sure that, and one that we end up talking a great deal about during handbook reviews. Make sure your statements about employment classifications are correct and consistent with what you're doing. If you have restrictive language about work rules, termination, disciplinary events, is it consistent with what your policies are right now? Do you have anything in there that looks like it's unionization-related terms, grievance procedures or recall standards? If they are, those look more like they might be seen as contractual. Even something like a non-compete agreement buried within a handbook may present problems for you down the road. And your acknowledgement form is going to be an important part of this too.
Tom, this is Lori. I have a question. Number 2, you state include a clear and apparent disclaimer. Can you expand on that, what that means?
Sure.
Please?
With some of the cases you'll see have come up, And the question is, what is the disclaimer and is it effective or not? The disclaimer generally focuses around issues such as, has the employer effectively reserved its rights to claim that this is a handbook that can be modified, that the terms of the handbook are it's not negotiated, that it's something that the employer controls. It runs concomitant with the at-will language. So this is the handbook right now, but we reserve the right to make a number of changes. We reserve the right to modify, amend this handbook as necessary. And I know from working with a number of you on handbooks that you're doing that. It's not drafting the first one, it's updating an existing one you have to reflect your current policies, your current practices that you decided to implement over the course of the business. But you'll see that when we come up with cases down the road.
Thank you.
Sure. Who's your audience? You think it's your employees. Well, it might be them, but it's more importantly these particular governmental agencies. These are the ones that are going to be parsing each sentence of your handbook, making sure that your practice and policy are consistent with what you present at a particular hearing or in response to a lawsuit. So who are they? Division of Unemployment Employers, probably one of the most frequent agencies that people go up against in terms of trying to litigate or trying to battle a claim. What does DUA do? They award unemployment insurance benefits to employees, former employees, and the question will be, typically, if you fired somebody for what you believe to be cause, why do they get unemployment insurance? And so, as you'll see when we get to that section, that is something that comes up quite a bit. But they can award up to 30 weeks of benefits. Those benefits then are charged to your account, generally, and that will adversely affect your experience rating down the road. NLRB, this is a newcomer to the process in many, many ways. The National Labor Relations Board has now begun to insert itself in the handbook process when it comes to at-will, when it comes to social media policies, when it comes to what constitutes a anti-union or unfair labor practice starting to show up.
Now, this is specific to both unionized and non-unionized employers, is something for us to focus on.
Absolutely right. And this is a new party to the table. I mean, you've dealt with unemployment for decades. You've dealt with the MCAD in the courts for a long, long time. National Labor Relations Board is in the last 3 or 4 years that they've begun to insert themselves into this process. MCAD, the Mass Commission Against Discrimination, obviously they focus on discrimination charges. What can they do? They can award back pay, front pay, emotional distress damages for somebody who believes they're a victim of discrimination and that somehow your policy or your handbook adversely affected them. It was seen as disparate treatment. They were somehow treated differently than any other employee because of the way the policies were implemented in the handbook.
Tom, any MCAD claim that I've ever gotten as an HR person always included a statement of what was the policy. Give us a copy of the handbook statement. Give me a copy of the acknowledgement form, every single case. Is that commonplace? Are there any cases where you wouldn't have request for policy in an MCAD case?
Hard to believe there would be.
So,
for the most part, it's always
every
there.
Single one.
But this goes back to the earlier point about, and DUA will do this as well, that they're taking a snapshot of your policy and only that policy in that moment. It may be seen differently in context, it may be seen differently in its implementation, but all they're looking for is page 12, your policy about whatever. And so that will be the focus of the entire event. The courts have progressively looked at handbooks. They look at them generally as contractual matters, so that you need to be aware of that even though you don't create a contract, even though you don't negotiate a contract, even though you try to avoid contractual-like language, they look at these as being implied contracts and read them generally against the employer, meaning that if there's a question of who's in favor or who's against, it's going to be read in favor of the employee and against the employer. Unemployment. So let's go to the meat and potatoes here. The agency most all of you have dealt with, almost everybody is either laid off or terminated an employee at some time. Here's the key language that unemployment looks at. By discharge shown to the satisfaction of the commissioner by substantial and credible evidence to be attributable to deliberate misconduct and willful disregard of the employing unit's interest, or to a knowing violation of a reasonable and uniformly enforced rule or policy. This is the language that benefits are denied. So the question becomes, can you prove that the knowing violation was a knowing violation? Was it a reasonable and uniformly enforced rule or policy of the employer? And so, back to my earlier point, these are going to be read against you as a standard. So this is what you're looking to test, typically be the test. A knowing violation of a reasonable and uniformly enforced rule or policy.
Then you'll win your claim.
That's right. Exactly
in
right.
theory.
So that gives a lot of wiggle room because, as we all know, when it comes to dealing with the legal system, reasonable is very much in the eyes of the beholder in a given time. So you have to be very aware of that. And you'll see with a couple of cases what's coming up, what we're going to do. Picked a couple cases, quick recitation of the facts. Employer has a written drug testing policy with disciplinary provisions, which many of you have. I see them all the time when I do reviews. Testing bases, random post-accident, with a death or where employee receives a ticket for a moving violation. Pay attention to those words because that's the problem. Employee signed for that, well aware of the policy. Company made a great deal of effort to promote it. There was an accident which led to property damage, so the employee was tested per the policy. Supervisor took the employee to the lab, got tested. Employee had not been observed to be under the influence of drugs. However, he tested positive for marijuana, so he was fired. The dilemma here, so he denied benefit, the appeal gets filed. He goes to, only the employee goes to the appeal. The employer does not. DUA, in its finding at the board of review level, agrees that the employee used marijuana, but based on the DUA standard above, which we talked about on the previous page, awarded benefits to the claimant. So what happened? Let's go back here. Post-accident with deaths or where employee receives a ticket for moving violations. That limiting language meant that the policy could not be used merely because he tested positive for marijuana. Neither one of those events had occurred. There had been no death, and there had been no employee receiving a ticket for moving violation. So Bill's here with his mouth agape.
What about their open drug policy?
What about the property damage?
Yeah. What about if they're open drug policy?
That is their drug policy, but it has these limiting clauses that says, here's our basis for testing. So what would you do? You'd want to open up a policy that says, if we determine that you have, if there's use of marijuana, you test positive for drugs, that would be an opportunity to use this. But what the DUA said is, aha, it turns out you didn't actually say this.
So he did not get a moving violation.
Nope, no moving violation. Actually happened on company property.
He didn't get a ticket for a moving violation.
That's right, happened on company property. Now, if they just said post-accident, if they said post-accident and eliminated the death language, they might have had a much stronger argument for making that point.
Now, given all that, let's say that were true to what you first
said. The employer
said.
didn't show up at the meeting, which they did on the appeal. They did not.
Right, on the appeal, would they have possibly won even though they didn't show up if the language was properly worded? Or
They have a better argument. They have a better argument for it. Yes, they would have had a much better argument. It would strike the two words with deaths. You know, or even if it said something like post-accident with serious injury, then the debate would be how serious is the injury? How, you know, someone hospitalized briefly at a serious injury, or someone hospitalized for weeks of serious injury. So language like that can come back and haunt you in terms of putting limitations on your ability. See if I can annoy Bill once again.
I'm sure it'll be easy.
Same one, a drug case. You know, drug testing does come up a great deal in the workplace, so we used a couple of these cases. Employer issues a drug policy in 1994 and 1998. So it's been around almost 20 years, this particular company, but the cases here arose in the early 2000s. Employee signed for it, was fully testing condition. Sent for a drug screen post-workplace accident. Collection center collected the specimen, sent it to the lab. Something all of you have done. Goes to the lab, sent it to the lab, make sure all of you are, something all of you have done. positive result came back from the drug test. The employee was terminated as a result of that. So he files for benefits. Goes to DUA, and initially the employer wins. But it's reversed on appeal. What's the issue? DUA cites the employer for failure to produce, that is to bring with it, a chain of custody certification from the collection facility. DUA examines the timestamps on the drug sample, on the urine sample, finds that there's inconsistencies with the times between when the sample was allegedly collected and when it was then transmitted, and that doubt raises a question about the validity of the testing. So as a result, they award benefit. So something that I had rarely heard about previously, which is having to document the actions of a third party, which is the drug testing lab, as opposed to yourself, is very, very unusual. But it means that if you're going to rely on the outside actions of a third party, like a lab, you want to make sure that that lab does what you believe it is doing and is consistent with your policy.
So moral of the story is just verify with your vendor, your drug testing vendor, an accounting of how do you handle specimens specifically, and audit them perhaps every once in a while, check every once in a while. I sent this person in, walk me through the process and the date and the timing and the stamping, just to make sure they're doing what they say they're doing.
I think that makes sense. I mean, any outside vendor, this comes up a lot in hotline questions, and the question is, where do I find a lab to do drug testing? And invariably, we talk about maybe calling your workers' comp carrier, your healthcare carrier, and see if you find someone. But I know we always say, go see the lab. See if they do what they purport to do. You know, if their chain of custody, their quality control is what you feel comfortable with, if you feel that the results are good, because ultimately, you're going to take action like this. You're going to terminate somebody based upon the lab, and you want to make sure that your policy and the practice of the lab that you're working with are consistent. So if you would send, think of it the same way. If you send somebody to an outside doctor for a physical exam, are they going to do what they say they do? And if the answer is yes, then you have a much better argument. If you have some questions about that, if you have some worry about that, that's going to be a problem. That's the concern.
Tom?
Yes?
This is Terry. Hi. Just one thought. I was doing an on-site at a place that had drug testing, and one of the other things that had happened was their policy stated that the company would be sending the specifics of the results instead of saying that the clinic that was doing the drug testing would send it, because the company doesn't usually get as detailed descriptions, and that was one of the reasons why they lost an unemployment case. So it's just kind of, as you said, wording.
I think we just lost you, Terry. I think where you were going is to say because the company had control of the drug test results as opposed to the lab.
Yes.
Okay. Sorry, Terry. I think you faded in and out. Sorry. But I think that's exactly right. That would fall under suspicion, quote-unquote suspicion, which is that somehow the employer may have been seen to taint the results of that as opposed to the lab, being able to produce its qualitative results.
Keep an arm's length away from the decision.
Right. So it's important to, but they're looking at the drug testing policy, and you can see how deeply DUA will delve into what the practices are of the employer, which the employer has documented in his policy. Something that, in fact, may even go beyond what's documented in the handbook, because most employers will not say, we use the ABC lab and here's their chain of custody and all that, but DUA was willing to use that as a way to explore the limits of how good the testing process was, and then ultimately award benefits. That's right. The National Labor Relations Board, Section 2, if you will, of this process, they're looking at 3 different areas in a great deal these days. One of them, at-will language. The employment at will that all of you have in your handbook, and we'll talk about in a minute. Go ahead. Social media and the social media policy that you may have. And discussions about terms and conditions of employment. All 3 of these are issues that the National Labor Relations Board is looking at, and all 3 of these, you'll notice, apply, as Laurie mentioned at the get-go, non-unionized work settings. In fact, the heart and soul of an at-will language statement is that it's a non-unionized work setting. So what's going on here? For some of you, you may have heard these, you may be aware of these discussions, but the at-will language the National Labor Relations Board is focusing on is to what extent is the employer's at-will language that is typically going to be in the opening page of a handbook, in the signature page, which also includes the disclaimer, and it may be in the disciplinary page. So it may be in 3 different places in your handbook. The language that says what we are an at-will employer. What does NLRB focus on? They focus on the following. Does this language appear to discourage employees considering forming a union? At some level, of course, that's part of what it's about. Emphasize the point that it's an at-will employer. But what they're looking at is, I'll give you an example of language that's unacceptable. I further agree that the at-will employment relationship cannot be amended, modified, or altered in any way. Language like that alone, the NLRB would find is problematic, because what that means is the employer is trying to say that there is no room for any discussion in any situation whatsoever. So when you look at what's going on, they're trying to say, if this language is so limiting, that's too restrictive. What's acceptable? Turns out what's acceptable would be something to the effect of saying, no manager, supervisor, or employee of the employer has any authority to enter into an agreement for employment for any specified period of time, or to make an agreement for employment other than at will. But it also says only the president of the company has the authority to make such agreement, and then only in writing. So what that means is, so CFO, CEO, president, whomever, if that person can amend the at-will language, then the NLRB says, fine, that's acceptable, because what that means is if all the workers were to unionize, they would go to the president to negotiate a contract anyway, and this language would mean that the company was open to that perspective. So this is a simple little look at your at-will language to make sure it's up to date, it's reflective of that, because if it's in there the other way and somehow a complaint is filed with the NLRB, then you look at the situation where you're inviting extra scrutiny for yourself of all your handbook, and you don't need that.
So it has to be open to change at some point in time, not closed off from any change whatsoever, that
Correct.
certain policy, and that change would be referencing at a senior level within the organization.
Right. And so it's a simple half a sentence that you can add that eliminates this whole problem if you do it that way. But it's clearly about the NLRB inserting itself in this process. The other thing is that the NLRB has put out a couple memos in this area, and they're saying at the end of the memo they're looking for at-will language around the country that they can further examine. So since the goal is to make sure none of you are the at-will target that being examined around the country, you want to take a quick glance at your at-will language. If you're about to get somebody like AIM to do a handbook review, make sure that we talk about this issue. If you're recently amended your at-will language or your disclaimer or your signature page, just make sure it reflects what is acceptable, what Laurie just added.
Yeah, and if you want to talk about it, please call the HR hotline, our employer's hotline, and we can kick it around just to make sure that you are in compliance. We're happy to do that.
One more thing. Yeah, okay, social media. The next big area, social media. Number of AIM members either have a social media policy or are thinking about creating a social media policy. And the NLRB first discussed this issue about 2 or 3 years ago, and they took the view, this is the equivalent of a water cooler. So Laurie, Bill, and I are sitting next to each other. The 3 of us chatting at the water cooler would be the equivalent in the NLRB's mind initially of what could be done on social media. So for example, out on Facebook, out on Twitter, out on any other website, that would be the equivalent. They've actually now taken some steps to change that view a little, and they now take the view that it can't be so sweeping, because in fact what's on social media may remain there permanently, whereas the water cooler conversation only occurs between the 3 of us and may never come to anything else beyond that. So they've evolved a little bit and thought about it more. So what they're now saying is that if you make disparaging comments about the company through any media, that's still being seen as illegal, because the employer cannot ban all conversation about the workplace out there. But an example of what's a good way you could do it, a safe example, to post or display comments about coworkers or supervisors or the employer that are vulgar, obscene, threatening, intimidating, harassing, or violating the employer's workplace policies against discrimination, harassment, hostility on any of the protected classes will be seen as very strong. So things that got close to bullying, things that got close to harassing, things like that, employer is on solider ground banning. Things that say you just can't talk about the company ever on websites, you can never mention our name, may raise concerns for groups like the NLRB.
How about confidential information, the employer's confidential information? For example, we have a new product that's coming out, and an employee posts it on Facebook before the launch.
Right. That probably not so much an NLRB issue as a breach of any confidentiality agreement that may exist or any non-disclosure agreement that may exist, which you may want to think about having. So if you're involved in work like that, involved in new product development or new new products coming out onto the marketplace, you may want to make sure that you control how that product is displayed and put in the marketplace. So in order to do that, you would need to have non-disclosure, non-compete, something along those lines. And that's the type of policy that would come up in a review discussion to say, if you have a little statement in your handbook that says exactly what Laurie just said, we don't want people disclosing things, that's probably not going to be sufficient. It's probably going to be more necessary to create a policy that says what specifically are you worried about or concerned about.
So the NLRB doesn't have an issue with us keeping our confidential information confidential. We just have to not inhibit employees from speaking with each other about the terms and conditions of their employment, or give that appearance that we're inhibiting.
Exactly right. Exactly right. That's where the focus is going to be. I mean, it appears anyway, and this seems to be a moving target, unfortunately, but it appears that more and more, they're focusing on exactly what you just said, Laurie, and if businesses still want to run their business in an effective way, which they intend to, that's generally fine so far. As cases come forward, we'll see. So, like it says, you can prohibit banning confidential proprietary information quite clearly. The other thing on social media policy, sorry, Bill, the one final thing on social media policy, the National Labor Relations Board has developed a model policy which is on the AIM Online Resource Center website. If you're looking for a social media policy, it is available there. So for members, you can go on the Online Resource Center. If you are a member and have not gone onto the Online Resource Center, now may be a good moment to think about doing so. It's www.aimnet.org. And when you get to the home page, you will look up in the upper right-hand corner. It says Online Resource Center. And if you've never been on, you'll have to log in the first time and create a password and do all the usual things. But it sits right there. It's fairly lengthy. It's about 3.5, 4 pages long. But it is the one, excuse me, the NLRB has blessed as its social media policy as of the moment. So if you're going down that road, that's a starting point to think about, and probably similar to the sexual harassment policy, it makes sense to rely on that one.
Right, through the MCAD, they have the model policy, and the recommendation from us is to use that similar with this. The verbiage in this policy, at least we know will be compliant if you use it.
Safe practice. The final bit of what the NLRB is up to. So you have a policy that effectively says to the employee, shh, don't talk about that. And it's about terms and conditions of employment, such as something like pay rates. This becomes a real problem for the NLRB. Recent case. This case came out following from about a year ago. Employer had a handbook policy that required employees to maintain confidentiality of certain company information, specifically compensation data. The handbook stated all employee pay rates are confidential and should not be disclosed verbally, written, or electronically for any reason with anybody without a valid reason, which would presumably be a written reason from senior management, which they were probably not prepared to give. This woman worked there 6 weeks. She told everybody who worked with her what her pay rate was. And her pay was higher than some of the other workers who'd worked there for longer. She got fired. Here's the problem that came up from the employer's point of view. The employer said she went to the NLRB and filed a complaint. NLRB said, well, why'd you fire her? They said inappropriate cell phone usage, lack of professional behavior. The company's HR director, however, had told unemployment insurance they fired her because she failed to follow the policy about wages and disclosing wages. So unfortunately, the company made two mistakes here. One is it told different stories to different governmental agencies, which is not a good thing to do. The second is that it really effectively didn't tell the NLRB the truth, which is why they fired her. And so it's a problem. The NLRB jumped all over that and said that the employer violated the NLRB by promulgating a policy that explicitly prohibits employees from discussing compensation. And that's unlawful on its face, unlawfully overbroad, and therefore violated the NLRA. So obviously two lessons out of this. One, you want to make sure whatever reason you decide within your handbook or your policy for what you're doing to terminate somebody is the reason that's the truth. You know, it's telling different stories to different agencies creates real problems for anybody when you're dealing with disciplinary matters. Because now that people have multiple agencies to go to and you tell different stories, you're going to end up with problems because people are going to compare notes, especially if somebody has an attorney. They're going to compare notes, they're going to catch, and there's going to be a problem. Second, to be aware of, the NLRB has far greater powers than any one of these other agencies. It can reinstate employees. It can demand payback wages, benefits, remove information, require you to post a notice in your workplace saying we violated the NLRA for a period of time. So again, types of things you want to be conscious of. You can't ban someone from discussing wages and conditions of overtime, things like that. Those are terms and conditions of employment.
This comes as a surprise to some folks, Tom, because sometimes we give people a raise and we tell them, please just keep this to yourself. We don't want others to be upset that we gave you more money than everyone else because you're a great performer. So it's unlawful for us to discipline somebody who in effect does just what we've asked them not to do.
You can ask them to do it and hope they'll do it.
Right.
But
if they tell everyone on the floor that they're making $15 more an hour than they are, and it causes a problem in the workplace, we cannot discipline as a result of that. That would be unlawful.
That's right, under the NLRA. So that's the problem. MCAD handbooks. Here, again, this is an agency taking a snapshot of looking at your practices. Here, the employer terminated a daycare employee for violating its maternity leave policy. You wonder maybe that was a bit of a bad setup in the beginning. Organization that deals with caring for young children is firing an employee for maternity leave. But the employee showed the MCAD that had the employer failed to present the evidence, the employee didn't keep in contact with them through the maternity leave. What happens? The employee went out on maternity leave. The employer had a series of ambiguous policies. For example, saying you should keep in touch, but it wasn't mandatory, that they needed to have a doctor's note and return to work, that wasn't consistently enforced. And so what they were able to show was that the policy promoted a great deal of inconsistency of flexibility, and that once that came up before the MCAD was able to look at that policy and say that policy is inconsistent in its enforcement, and therefore it represents a disparate treatment. This one woman is being treated differently than other employees, so that violates the discrimination laws. If you take time to draft a policy, make sure it's consistently applied to all employees and there's no room for ambiguity. So if you want doctor's notes, you can do that. But make sure you ask it of everybody. Or if you don't want doctor's notes and you can live with that, that's fine too for different things. Make sure your policies are consistent in how you enforce them. And this is really a concern, frankly, for your supervisors, because many supervisors at the front lines may act differently. So Bill's a supervisor, Laurie's a supervisor. They may take different cuts on different things. And that represents a problem, because if that's inconsistent with your handbook, one of their practices, it represents a problem that employees will become aware of. And they'll say, no, Laurie never asked for that, and Bill does. So, what's the policy?
So bringing all your supervisors in a room and going through policy by policy maybe. Every week we're going to go through one policy and answer questions. This is what you would do in this type of situation. If you have someone who's been out for 3 days, this is how we handle it. So everybody is on the same page, and perhaps every disciplinary action is housed through one person in the organization, whether that be HR or whomever, depending on how big your organization is, meaning any written disciplinary action has to go through one person first before it's delivered. That one person can make sure we're consistent in our approach in addressing a problem.
Absolutely right. I mean, when I do handbook reviews, this comes up all the time, and the question is that I'll be asking the HR person is, are you making sure all your senior managers, supervisors, frontline people are on board with what's in this handbook? Because they're going to live and die by it. HR will be typically one step removed and hear about it after the fact. So Lori's summary is exactly right. Finally, some of the court cases about handbooks. There's very, very quick. But when I do handbook reviews, this is what I'm always conscious of and thinking about. Back in 1988, the courts took the view that handbooks are not contracts. It's not negotiated. There's no evidence drawing a special contract. Employer has the right to modify. But basically, since then, the courts have been narrowing that provision and giving more and more authority / power or weight to what employees do. So, for example, 1996, the employer didn't put in there that it had the right to modify or through its disclaimer, meaning the employee had the right to expect all provisions would apply from the handbook when she signed it. So the company learned the lesson here, which is you have to have language in there that gives you the right to modify it. Interestingly enough, the employer won this case because the employee didn't follow the handbook. It didn't follow the handbook policies about filing a complaint. So it actually worked out in that case, but the lesson was if you don't have some sort of saving language in there that allows you to modify it, it creates a problem. Ferguson. Could an employee reasonably believe the handbook contained enforceable promises? In this case, the court said the disclaimer was buried in the fine print. It was not obvious and clear to an employee. So that's the type of case that could work against an employer. You want to make sure it's up front and center, signature page in the beginning, so it's obvious to an employer. In Ortega, company had both progressive discipline and the disclaimer. Employee admitted signing it. Employee got fired after he overstayed a vacation, even though he called in to say he couldn't get back due to travel-related reasons. The court said the disclaimer was not specific to the discipline policy. I know when I look at discipline policies in your handbooks, a number of them will have this provision that says, but the company reserves the right to take more significant disciplinary action depending upon the circumstances, or something to that effect. That's the type of language that Ortega drives home, that if there isn't that language within the disciplinary policy, the company faces a greater risk of losing the case. Buttrick, recent case, employer claim included a disclaimer that the court said was ineffective because the court said that when the company kept insisting the employee sign the handbook and demanded the employee sign the handbook and tried to coerce the employee into signing the handbook, that made it sound more and more like it was looking contract-like. Also, the handbook contained a full non-compete policy within it, or non-disclosure policy within it, rather. No, non-compete, I'm sorry, non-compete policy within it. And so the employee thought, okay, I'm bound by the non-compete policy contained within the handbook, which means it looks like a contract. So the lessons here is if you have things in there that make it look like a contract, it's probably a problem for you. If you have a non-compete agreement or non-disclosure agreement or something like that, you may want to reference it in the handbook, but then put it separate so that there's a person actually signs something and is aware of what you will do and removes that from the handbook. Probably a safer practice, a code of conduct, an ethics policy, all those things. Okay, that's our quick tour through what's going on in the handbook world. I would encourage you, review your handbook for problematic language, meaning, back to my earlier point, will Laurie and Bill interpret this language the same way when it's on the front lines? That's what you want to make sure will happen. Have fresh eyes do it. AIM can do this for you. I do this all the time in handbook reviews and policy reviews. And if you're making changes, be clear why you're making that change. What's your goal? Is it to try and make the policy more workable? Is it try and really change where your operation of your business has changed? make sure that you can do that in a way that people understand.
And also, I think it's important that your frontline supervisors understand the policy and how we go about interpreting it, that we're all on the same page. So training them and having them understand what the policy says and how we react to it as an organization would be very, very helpful as well.
Okay.
To ensure consistency. I think there were a couple questions, Tom, that came in.
And Tom, this is Terry. Can you hear me?
Terry?
Can you hear me okay?
Yep.
Okay. I don't know if you want to mention the
I
model
can.
employee handbook.
Oh, well, go ahead.
The AIM has a model employee handbook. If somebody does not have a handbook currently and would like to know where to get started, not sure where, we do have a model employee handbook that our members, we make available to them. We sell both member and non-member pricing, has all of the state and federal policies as well as most common policies. So be happy to answer any questions about that if you want to provide my contact info.
Excellent. And that actually segues right to the subscription service too, Terry.
Yep.
Which we try and update policies on a regular basis, put them in new policies as appropriate, and put them either on the online resource center or, no, that's wrong, put them out through the subscription service, sorry.
Right. We'll send an email to people on the subscription service directly as we do any updates.
Right.
Hey, Tom, we have two questions. One question is relating to the second UI case that we discussed earlier. A company on the line does on-site saliva drug screens. What would constitute a chain of custody or proof of having failed a drug test in such a situation?
They would have to be able to document their procedures for how they do it. I'm presuming a company like that would probably be medically based, that they would have the capacity to do drug testing or saliva-based tests or things like that. Maybe not, but you'd want to be able to document that the chain of custody from the moment it came from the employee through the testing process was in such a way that the sample could not be tainted, that it was in containers that were sterile, that it was handled in such a way as to not be tainted by any other outside influences on the outside bacteria or anything like that, to make sure that it was a true sample. That's unusual. I don't usually hear of too many companies beyond medical organizations doing that. So.
Okay.
They might want to have that process reviewed by an outside party,
Right.
So they can verify the compliance aspect of it,
Right.
have it documented, and fix any parts of the process that aren't fully in compliance.
A lot of times they do that by mail. I mean, I've seen staffing agencies do that before, where it's kind of they take the sample and then they have to mail it in for results, I believe.
Mm-hmm.
Okay.
So it would be the taking of the sample that might come into question, perhaps.
Correct.
Right.
Okay, great. We have one more question, and this one relates to the terms and conditions slide where we talked about the payment of employees. Do the previous NLRB policies apply to only union employers or to all employers regardless of whether they are union or not?
Now this, if you all recall, was the question, can we discipline folks for talking about their pay, right? And the question is that just for unionized or non-unionized? And it's for all employers, non-union as well as union.
There are these few sections of the National Labor Relations Act, and many people think, oh, it's unfair labor practices, it's the unions and all that, or union drive. Not at all. Segue on what Laurie said. It's the non-union work settings that are still subject, because people are talking about terms and conditions of employment that apply to a union or non-union setting. And so it's just this NLRB has become more and more upfront in terms of getting involved in these situations. Actually, since we're getting close to the last quarter of the hour of the presentation, I want to turn it over. We may have more questions that come in, and we'll take care of that as we do. But we're going to turn it over to Bill Baldino, who's going to talk about updates on the Workforce Training Fund, what's going on. And I don't know if, Carrie, if Bill received any questions. If Bill had received any questions in anticipation of his presentation.
We don't have any questions for Bill right now.
Okay. So if people do as they go through the presentation, by all means send them in through Carrie, and she will be able to talk. Now, otherwise, Bill Baldino.
Good morning. So we have been sending out some information and trying to get the word out that there have been some very good changes that have occurred most recently. Actually, on April 23rd, they were announced on the Workforce Training Fund program. These changes are meant to streamline the process, make it easier for companies to go ahead and get some funding for their training. And in some cases, some of these we're going back, reverting back to policies that we had in effect a few years ago. So, but the most significant ones that I thought are, in my opinion, is the Express Grant. The Express Grant program is the beneficiary of two really, really excellent policy changes. Now, if you are familiar with the Express Grant, you know that it just as the name implies, it's a faster way of getting some funding help for your training needs. It's a 50-50 proposition. That is, if the training costs $1,000, you are going to pay the training vendor $1,000, and as long as it's an approved course, the fund will reimburse you $500. So it's a 50-50 proposition, and you have up to 2 years to do the Express Grant, and there are several rules around it, but it really is a fast way of getting funds. And here's the significant thing: for up until April 23rd, the Express Grant was always for companies under 50 employees. Now that has changed up to 100 employees. That's very, very significant. It's going to give a lot of companies the opportunity to do some training that they didn't have opportunity to do before, that they may have needed to go to a general grant, which is anyone who's gone through that process knows it's a much more extensive process than the Express Grant. They may have only wanted to have one type of training or something. But so this is going to let companies up to 100 people access the Express Grant.
Bill, is that 100 full-time employees or just
full or part-time employees?
Or part-time?
Okay.
It's a combination of both.
It can be a combination of both, right? And then the other significant thing, and this is one of those policies that's kind of a revision. Is that the right word? Reverts back to a few years ago when the Express Grant actually there's the eligibility to go from an Express Grant to a general grant has been eliminated. So now, if you have an Express Grant and maybe you started some training, maybe it was a training pilot that you decided to do under the Express Grant, and now you saw that training is really, really good stuff. We want to continue this, and we're going to do this on a much broader scale. Now you're going to go through the general grant. Well, you don't have to wait a year or 2 years to do that. Now you can, as soon as you close up that Express Grant, you can be ready and eligible for that general grant. Now, that's a big deal too, because a lot of companies had used the Express Grant as a training pilot, an opportunity to see what effect that training would have on a particular issue that they're trying to resolve.
Bill, can I ask you a question?
Sure.
So in the Express Grant, I think you mentioned you have up to 2 years to implement whatever it is.
That's correct.
But in order to get the general, I have to wrap up the Express.
You have to wrap it up. Yes. Yeah. You can't have both open at the same time.
Right.
Although you used to be able to do that, they haven't changed that part. But that's okay. You should really close up these things anyways. That's a very good policy to have in place. Okay, so now we talk about the general grant. Now, if those of you who have been involved in the general grant or ever had one, you know that general grant can get eligible companies as much as $250,000 worth of training. Now, to get $250,000 worth of training, your company has to be large enough, obviously, to support that amount of training. But that's what's available to you underneath this grant. And what is significant about this change, which is there was a period of time where you do your grant, then you close your grants. You have 2 years to do that grant. Then you need to close it out, make sure all the paperwork is in, make sure the contract is closed and signed up. Then your clock started ticking for a 2-year period before you could apply for another grant. Now that's a long time. And that's a long time in between, to put off some training that you otherwise might have undertaken. So recognizing that, the Workforce Training Fund has reduced that to 12 months, which is a reasonable amount of time. It used to be 6 months way back, right? A number of years ago, and then it got raised, and now it's 12 months, which is far more reasonable because you really need that year to make sure that your training, whatever impact you were looking to get out of that training, is continued. That you've been able to sustain the training, and that that going for another training, another major training program is something that's really in the cards for you. It's something that you can really handle. But that is significant because 2 years is way too long, and I think this 12-month period is very good.
Bill, may I ask you a question on this?
Sure.
Is that by employer or by site? So if I had a site, say Boston and one in Springfield.
That's a really good question.
Okay.
And it really has a lot of complications in that because the first eligibility for the Workforce Training Fund is based on really FEIN number. It's one of the characteristics. So if you have 3 companies and you're all under the same FEIN number, one's in Boston, one's in Springfield, and one's in Bridgewater, and you get a Workforce Training Fund grant for your Boston company, and it's under that FEIN number, you've actually eliminated the opportunity for those other companies.
Really?
That's right, because you can only get one under that FEIN number at a time. Now, that 12-month period elapses, you can go for the one in Springfield.
That's good to know.
So that's right. So if they had separate, same company but separate FEIN numbers, no problem, because they're going to base it on that FEIN number, and you can have that company can have a couple of different grants going at the same time, realistically. But so if you're a company in that situation and you have a couple of divisions or different locations all under the same FEIN number, when you're considering your training, consider all of the companies to participate. Okay, but that's a very, very, very good point, Tom. Okay. Something a lot of people forget about. Technical assistance to grants. Now, this is something that doesn't get a lot of use. And it's the best way to kind of explain the technical assistance grant is that this is for companies who don't know what they don't know. So
It's good to know.
So it's going to help you help a company assess the type of training needs that company might have in order to resolve a problem or move forward or whatever it is they're trying to accomplish with their training. So let's say a company has some issues, keeping that bottom line intact, which all of our companies do, right? So they're trying to find out, okay, where is the problem? Where's the problem emanating from? So you can get the assistance of a vendor. Could be AIM, could be Mass MVP, could be some, a number of other organizations that can come in and help you do an assessment. Find out where the issues are. Could be in sales, could be in operations, could be in finance, could be in a lot of different places, could be a combination of all of them. And you do the assessment, you find out what types of training can be used to mitigate or resolve those problems, and then you can figure out what that training is using this grant, and then no waiting period, go right to general grant and get started on doing some of that training. Now, what's happened, is that so what the change is, we've always had this technical grant, I guess, and as I said, a lot of people do not make use of it. But and one of the reasons may have been because it's only a 6-month program. You have to have it go through this process in 6 months. Now it's up to 12 months, so it's going to be much easier for a company to be able to do the application, get it approved, be in a position to do that assessment, and get it completed now within 12 months, so they can go forward with the next grant, which is probably a general grant. So
checking to see if there were any questions.
Okay, so if there are there any questions about these are the significant changes that we have with the Workforce Training Fund right now.
Well, I believe there is one question. Yep.
Hi, Bill. We have one question. There's a company that had an express grant that ended in May 1st.
Yep.
They didn't use all of the funds allowed, and they're wondering if this will impair them from applying and being approved for future grants, and also what's the waiting period for them to apply for another grant?
No, it will not. No, it will not impair them from. No, it will not impair the company from applying for another grant. That often happens, that companies will do some training, whether it's an express grant or the general grant, and because things happen in business, they don't always get the chance to complete that training task, so they don't spend all the money. Well, that's okay. Okay, I'm sure that everybody would prefer to have been able to finish it, but sometimes it doesn't happen. So that does not impair their ability to get another grant, subsequent grant. The question about is there a waiting period between express grants, between the close of one express grant and the opening up of another? That's a good question. I'm not certain I know the answer to that. Logic would tell me that there would be some time delay, but I can't say that. I'm not certain of that. I'll have to find that out myself. That was actually a question that came up yesterday that I had hoped by somebody else I hoped I would have an answer to today, but I don't. There's no delay to go to a general grant. You can start that right up, but to go to another express grant, I don't know. I'm not sure of that answer.
Okay, we actually have one more question that just came in. If you've had a general grant already, can you apply for an express grant?
Yes, you can. You can definitely, as long now, and that puts more companies into that arena now, right? Because if you've already had a general grant and your company was under 100 employees, now you want to do some additional training. You don't need to have this big lot, this large grant and all the work that goes along with it. You want to just continue on with some specific training. You can go ahead and use the express grant.
Okay, thank you, Bill.
Okay.
Bill, can I ask you one quick question?
Sure.
Based on your experience in doing different orientation sessions and all that, what are people using the grants for nowadays?
The use of the grants is still primarily, okay, my experience is that primarily we're using this for leadership training, leadership development, supervisory type training, a lot of customer service, and now a lot of ESOL training is going on. Okay, in all different parts of the state, and this is becoming a big push of the grant because there's a huge need for it, and there's a lot of it going on now. And of course, also lean is also a big component, which is not only for manufacturing companies but for other business types as well. In banks, in healthcare, lean is a program that is readily funded by the Workforce Training Fund.
So employers should really cast a pretty wide net when they think about what a grant might be for.
I always tell companies that they should be thinking that it's easier to answer a question of what's not covered than what is covered, because most stuff is covered under the Workforce Training Fund. There's only a few types of training. For instance, safety training, unless there's something really specific, is not going to be covered under the Workforce Training Fund. That's something that you should be doing anyways. Harassment prevention training is a cost of job doing business. So these types of things are not covered, but just about everything else is.
Excellent. Thanks, Bill, very much. Laurie, Terry, thanks everyone. Terry, do you have any final thoughts?
I'm sorry?
Yeah. I was going to ask if you had any final thoughts since we're about to close.
Yeah, I mean, just real quick, the one question I thought of, Tom, is that a lot of employees or employers have asked us on Hotline, when an employee provides you a notice and you don't want to keep them, what are the examples of when you should pay them out versus not pay them out, and it usually has something to do with what they've written in the handbook.
Well, sometimes I know employers put in the handbook that they will pay people, that they will say, ask for 2 weeks' notice, the person gives two weeks' notice, and you decided for whatever reason, business-related reason, you don't want that person on the property. Their fear of, morale issues or access to IT systems or who knows what. So generally in cases like that, you would want to, we would always recommend how you pay that person to go away. It's relatively cheap investment to pay someone 2 weeks' pay if that's what your handbook calls for. So the thing to think about in your handbook is, do you want that in the handbook? If you do, you're going to have to live with it. If the person comports themselves and they comply with whatever you ask for, the 2 weeks' notice, then I think you have little or no choice.
And if you want to handle it on a case-by-case basis, of course, just keep it out of the handbook entirely.
Exactly right.
And depending on the certain situations, you can make the call what you wanted to do.
A little bit here, just as we close, if you're looking for more information about what AIM does in the world of handbook reviews, Karen Choi, and her email is right there. If you're looking for more information on the Workforce Training Grant, Bill Baldino's email. Just make sure you put W for William as opposed to B for.
Actually, it works both ways.
Oh, it does? Okay. So both work. Then B Baldino and W Baldino both work. And you can get in touch with both of them through their AIM emails. And what Laurie said earlier, if you want to come call the hotline, you have specific questions on something like that very issue Terry just raised, then call the hotline and we can talk through the issue. Otherwise, thank you very much for
everyone for joining us.
Joining us today. And if you have follow-up, by all means, get in touch with us through the hotline.
Be happy to help. Have a good day.
Thank you.
Thank you. Bye-bye.
Bye.